This video presents an overview of the law and practice of the United Nations Security Council. Let's begin by recalling why the UN was established. Its primary mission is spelled out clearly in the first article of the UN Charter. The aim of the Charter system is to avert another world war by taking effective collective measures for the prevention and removal of threats to the peace, and by facilitating settlement of international disputes or situations which might lead to a breach of the peace. As we will see, the Security Council was conceived to be central to both aspects of that mission, to serve both as police in a limited array of circumstances and as a referee in a somewhat broader set of contexts. If we zoom out, we see that Article 1 also speaks of justice, international law, equal rights, self-determination, and international cooperation. An abiding question is to what extent the Security Council's structure and mandate serve those values. Let's look at the function and powers that the Charter assigns to the Council. Under Article 24, we see that the Council has, quote, primary responsibility, unquote, for the maintenance of international peace and security. The General Assembly, to be sure, is not entirely denied a role in this area. As you may recall, the General Assembly is also empowered to discuss questions related to the maintenance of international peace and security, and even to make recommendations on that front. And, as we saw, the General Assembly has at times done exactly that. For example, leading the way in expressing concern about the effect on international peace and security of South Africa's apartheid policies and recommending that states take action to isolate South Africa economically and militarily. But in several ways, the Charter makes clear whose authority in this context is supreme. First, Article 25 obliges UN members to accept and carry out decisions of the Security Council, so long as they are in accordance with the Charter. In contrast, the UN General Assembly is limited to making only recommendations. It is not empowered to take binding decisions in the name of the UN organization. Second, as we see in Article 12, the General Assembly may not make any recommendations regarding a dispute or situation while the Council is exercising the functions assigned to it in relation to that dispute or situation. That said, Article 12 has come to be interpreted somewhat narrowly. Initially, both the General Assembly and the Security Council interpreted Article 12 to mean that the General Assembly could not make recommendations about any question so long as the matter was on the Security Council's agenda. However, as the International Court of Justice explained in its advisory opinion on the legal consequences on the construction of a wall in the occupied Palestinian territory, quote, there has been an increasing tendency over time for the General Assembly and the Security Council to deal in parallel with the same matter concerning the maintenance of international peace and security. The court goes on to say, it's often the case that while the Security Council has tended to focus on the aspects of such matters related to international peace and security, the General Assembly has taken a broader view, considering also their humanitarian, social, and economic aspects. A third way in which the supremacy of the Security Council is affirmed is in relation to the use of force. Article 2, paragraph 4 of the Charter prohibits the use of force against the territorial integrity or political independence of any state. But as we shall see, the Charter allows the Council to authorize such a use of force in circumstances where international peace and security are threatened. The United Nations General Assembly is not granted the same power. Let's now look more specifically at the Council's dual role. Its first role is to promote the settlement of international disputes. As a threshold matter, consider the diverse roles that a third party may play in facilitating the settlement of disputes. We can chart these roles along a continuum from less intrusive on the left and less binding, and ergo more political, to, on the right, more intrusive, more binding, and ergo more legal measures. At one end, the left end, we have good offices. In the Max Planck Encyclopedia, this is defined as a technique of peaceful settlement of an international dispute in which a third party acting, this is important, with the consent of the disputing states, serves as a friendly intermediary in an effort to persuade them to negotiate between themselves without necessarily offering the disputing states substantive suggestions toward achieving a settlement. So good offices is really about convening parties to a dispute, encouraging them to talk to each other, maybe even providing a space within which they can talk, and a reliable messenger to facilitate communication between them. Next, we've got mediation, which is similar to good offices, also involves consent, and with a third party undertaking to facilitate communication between the parties. But mediation can sometimes involve a more active role on the part of the mediator. Rather than simply convening the parties, there may be a more active effort to crystallize what the parties' positions are and facilitate more robust communication between them. The line between good offices and mediation in the literature is a little bit blurry, as is the line between mediation and conciliation, the next step on our continuum. Conciliation, as it's usually imagined, is a method for the settlement of disputes according to which some sort of commission or entity set up by the parties proceeds to examine the dispute impartially and attempts to define the terms of a settlement of a dispute. So whereas mediators tend, in the classical definition, the traditional sense of a mediator, tend not to recommend how to resolve a dispute, conciliators do make such recommendations. Finally, we have the idea of inquiry. And inquiry is very much like conciliation, except its focus is specifically on finding facts. So recognizing that varied perceptions of what happened can very often drive the perpetuation of a dispute. What inquiry undertakes to do is to empower a third party to enter a situation and ascertain what the facts are, with a view toward providing an objective account that both parties might then be encouraged to live with and treat as a basis for resolution of further resolution of their dispute. Now, as we get to the other end of the continuum, we have two forms of binding third-party dispute resolution that are much more legal in character: arbitration and judicial settlement. The key difference between them is that judicial settlement tends to be effected by standing institutions rather than tribunals created specifically for the dispute in question. In addition, judicial settlement tends to be more public and more transparent. Although there's some variation on this front, you can have elements of that in the context of arbitration proceedings too. So how does the Security Council play these roles? Remember that under Article 2, Paragraph 7 of the Charter, nothing contained in the present Charter shall authorize the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state. So this serves as a barrier to the Council exercising even dispute resolution functions under Chapter 6 of the Charter. However, in order to overcome this barrier, the Council may find that a dispute is likely to endanger international peace and security. And so Article 33, which provides that where a dispute, the continuance of which is likely to endanger the maintenance of international peace and security, is in play, that the council may address itself to those disputes. This provision serves as kind of a trigger and as a means of transgressing the barrier established by Article 2, Paragraph 7 of the Charter to council action. Once that power has been triggered, there are a number of steps the council can take, either under Chapter 6 of the Charter or under Chapter 7. As you can see, they're similar to the functions that I sketched a moment ago. So we have under Article 33 something analogous to good offices, calling on the parties to settle disputes themselves. Under Article 34, the Security Council may investigate any dispute or any situation which might lead to international friction in order to determine whether the continuance of it is likely to endanger the maintenance of international peace and security. Under Article 36, the Council may recommend procedures or methods of adjustment. Under Article 37, 38, and 39, under Articles 37 and 38, the Council may also recommend terms of settlement that it regards as appropriate. And then finally, as we'll see, the Council can cross the line in Chapter 7 to more intrusive measures. We'll get to that in just a moment, but let's look at the details a little bit here. When we talk about Article 34 and this investigation power, you may be wondering, so what exactly might be investigated? Here's where we've got a few examples from council practice of the kinds of things that the council gets involved in investigating. So in Resolution 15 of 1946, the council created a body to investigate what happened along the border of Greece that was contributing to exacerbate the Greek Civil War. Similarly, in 1948, under Resolution 61, it called for the investigation of breaches of the truce between Arab states and Israel, with a view toward reporting on further measures that might be appropriate to take under Chapter 7. With respect to Article 36, there are a few different kinds of procedures that might come into play. So we can see that under Article 29 of the UN Charter, the Council is empowered to establish subsidiary organs, for example, to create a mission and send that mission into a site of conflict with a view toward creating a framework for mediation or fact-finding or conciliation. Under Article 36, Paragraph 3, we see that it is possible and it's encouraged for the Council to take into consideration that legal disputes should, as a general rule, be referred by the parties to the International Court of Justice in accordance with the provisions of the ICJ statute. That said, Article 36(3) has been very rarely invoked. Indeed, there's only one instance where the Council referred a legal dispute over to the International Court of Justice, and that was in the Corfu Channel case. It's a pity, indeed, that this particular mechanism hasn't more often been utilized. And, of course, the Council is entitled to recommend other kinds of procedures according to its discretion. Examples of the Council exercising its Article 36 power include the Council referring Britain and Albania to the International Court of Justice, as I mentioned already, in the Corfu Channel dispute, inviting Israel and Syria to take armistice disputes to a mixed armistice commission, and in 1967 establishing a mediation mission for Arabs and Israelis following the 1967 war. Now, when we turn to the functions of the Council under Articles 37, 38, and 39, we see the Council crossing into a role of recommending substantive terms for the resolution of a conflict. And you may be asking, so what's the function of the council doing that? Why make recommendations? How does that help to resolve a conflict? And the literature suggests that there are three distinct roles that we can think of. One is to try to contain the bargaining between two parties. To the extent that the council recommends terms, then it makes it less plausible for parties to demand outlandish things. It reins in their likely demands, or at least can in theory, in order to make the agenda for negotiation of a resolution of their dispute more manageable. Recommending substantive terms can also facilitate communication between parties, give them a vocabulary with which they can deal with the issues before them. And it can provide domestic actors with political cover. It's much easier for them to be able to say, I'm only doing this because the most powerful countries in the world are demanding it of us, rather than to rely on their own political courage to take a difficult measure and resolve a conflict. Examples of this effort, of this kind of function being exercised, we've got Resolution 95 from 1951, where the Council demanded that, or recommended to Egypt that it let ships through the Suez Canal. Resolution 47, where it recommended that India and Pakistan hold plebiscites to settle the territorial dispute between them about Kashmir. Resolution 774, where the Council urged Greeks and Turks to create a bi-zonal and bi-communal unified country of Cyprus. Finally, we turn from Chapter 6, which is focused on the dispute resolution role, to Chapter 7, which is where the Council plays more of a peace enforcement role, a policing role. And here, under Articles 41 and 42, the Council is empowered not just to recommend, but to decide. And I want you to note that language, that when the term decide is used in Security Council practice, then that means that the Council's decision is legally binding, whereas a recommendation is not. And under Articles 41 and 42, the Council is empowered to decide on both measures not involving the use of armed force, such as the imposition of sanctions, and measures that do involve the use of armed force, such as authorizing member states to use air, sea, or land forces to deal decisively with a threat or breach of the peace, threat to or breach of the peace. Now, as you know, because it's one of the most famous features, most notorious features of the Council, permanent members of the Security Council possess veto power, at least on substantive matters. So whereas procedural matters may be decided by an affirmative vote of 9 members, a majority vote, decisions of the Council on all other matters must be made not only with a majority vote, but also the concurring votes of all permanent members. Now, as things have unfolded, it's become possible through a more flexible interpretation of the Charter for Security Council members to abstain from voting and for a measure nevertheless to go forward. And so it's not actually necessary that the concurring votes of all permanent members be there so long as there are no opposing votes. But Security Council members, permanent members, do have the right to veto any substantive decision by the Council. Now, that doesn't mean that the veto power is completely unconstrained. The Council does have primary responsibility for the maintenance of international peace and security, and in discharging these duties, it's meant to act in accordance with the purposes and principles of the UN. And these dual responsibilities have been the basis for a lot of discussion about how to constrain or to reform the Council, the veto power of Council members. One important development on this front is what's come to be referred to as the Uniting for Peace framework. Bearing in mind that the Charter is a living document, interpretation of its provisions have evolved over time in response to challenges faced by the world. And one of the most formidable of those challenges has been figuring out how to deal with the political dysfunctions within the Council itself. In that context, some have urged that the General Assembly should play a more significant role. In fact, as early as 1950, a framework called Uniting for Peace was developed to provide for an enhanced General Assembly role in circumstances where the exercise of a veto by a Security Council member prevented the Council from exercising its primary responsibility. That framework has been steeped in controversy and to some extent hobbled in the decades since, but it stands out as a reminder that there is some room to adapt and even depart from the Charter's text when it's necessary to respond to the exigencies of global affairs. As you reflect on these powers, think about how they played out in relation to the Council's engagement with apartheid South Africa. I encourage you to go back to the key resolutions and compare them. Note that in Resolution 134, we see that the Council does call on the government of South Africa to initiate measures aimed at bringing about racial harmony, but it doesn't speak in the language of enforcement. We see here an attempt instead to deal with a situation that might lead to international issues of international friction, as the Council puts it, without moving from Chapter 6 to Chapter 7. This is similarly the case in Resolution 181 of 1963, where the Council suggests that the situation in South Africa is seriously disturbing international peace and security. And though it calls upon states to cease forthwith the sale and shipment of arms, ammunition, and of all types and military vehicles to South Africa, again, it doesn't use the coercive language that it must invoke in order for Chapter 7 to be called into effect. And here, a final contrast is presented by Resolution 418, adopted in 1977. And look at the ways in which we see Chapter 7 powers being invoked. In the preambular language, only part of which is presented here, we see the Council saying that it is acting under Chapter 7 of the Charter. Also, note in paragraph 2 that the Council decides that all states shall cease forthwith to provide South Africa with arms. And paragraph 4 decides that all states shall refrain from cooperating in the manufacture and development of nuclear weapons. So we see a meaningful difference in language and accordingly in binding effect of these different Council resolutions. And as you reflect on the Council's role, it's useful to ask, did the Council help or did it hinder the struggle of South Africans against apartheid? When we look at the role of the individual states on the Council, did the presence of a Security Council, the existence of a Security Council, enable concerted effort eventually? Is it what made it possible in the ultimate event for the world to pressure the apartheid regime to take action that it was clearly unwilling to take for many years? Or did the existence of the veto power effectively slow down global efforts to bring that regime to its knees? I don't intend to offer a definitive answer to that question, of course, but I encourage you to think about it. Thanks very much for listening.